financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Good morning. Welcome to this segment of Law and Reality. Today's topic, covenants not to compete. Before I say good morning to the crew, I want to quote Jerry the bartender. You can't stop someone from earning a living. Don't worry about it. They won't sue you. Good morning, Jenny.
Good morning, Ken.
Jenny Wingle, always nice to see you. Brian Small.
A pleasure, Ken.
The men are in blue today. Brian Small, David Einstandig.
I think you're in teal.
Those men are in blue today. This man is in teal.
But you know what? How long have you been practicing?
Many years, 33 years.
In about 46 here, so we're at about 100 years. In the 100 years,
4 years.
In the 100 years collectively, or 115, 20 years collectively, I don't think we've had one bartender that we had to do a covenant not to compete for.
Probably not. And Jerry's not necessarily our biggest fan anyway, because we've been picking at him for the better part of 8 years.
But he pours a pretty good drink.
Hey, he
does pour a
tells you
good
what
drink.
you want to hear.
Well, the whole point of why we pick on Jerry the bartender is it's easy. It's not just Jerry. Everyone's always giving advice, and everyone always likes to be a know-it-all, and that's great if they know it all. But when they're giving advice and talking about things they really don't know about, it's dangerous. And in this case, when we talk about covenants not to compete, let's evaluate it in the context of what Jerry says is what many clients call me up and they say, you know, my daughter's signing an employment agreement. There's a covenant not to compete. It's not enforceable, is it, Ken? I don't have to worry about it.
And then the other thing they say is, they're going to tell you that, and then they're going to say, oh, it's standard. They're all standard. It's a standard form.
So I might as well just sign it.
You know, because how many times have you heard standard from a client or anyone else?
Standard form, standard purchase agreement, standard lease, standard employment agreement, standard purchase agreement, standard transmission. Oh, that's manual transmission. All right. What is a covenant not to compete? Wikipedia gives us a definition. I always like to, so we put it up on the slide and you see, but this isn't a bad, I looked at a lot of definitions. A covenant not to compete is a clause or a term used in contract law where one party, it's usually the employee, agrees not to enter into or start a similar profession or trade in competition against another party, usually the employer. That means in an employment agreement, or if you sell a business, you see a covenant not to compete because the buyer wants to make sure the seller doesn't go and start competing against him after the buyer pays for the business.
And right off the bat, when you're dealing with the sale of a business, those covenants are looked at much more favorably from a court or an arbitrator because you're selling a business. You expect the next day not to have the buyer who just paid competing with you.
Yeah, because there's an obvious legitimate purpose there because you wouldn't pay for the business and run the risk of having the guy who's selling it to you steal all the business that he just sold you.
Or
Well,
it
in
would be
respect to things like restaurants and that, it has to be reasonable. So if you were looking at it saying, I have an enforceable covenant not to compete, you just sold the business to me, usually there's a time frame involved, and then there's also mileage. It's not anywhere in the United
Absolutely.
States.
If Barney's Deli sells to Brian, and Barney's Deli is located at 15 and Telegraph, and the covenant not to compete says you can't operate a deli anywhere in the state of Michigan for 20 years, there's no logic to it unless Barney's had outlets all over the state. So you have to evaluate it in those contexts. But there's one other area that comes into play. I want people to realize it's not only employment agreements or sale of business. Also, oftentimes there's an independent contractor service agreement where you engage a professional or you engage a sales representative and you're not hiring them as an employee. you have an independent contractor relationship, but you still don't want him to leave and go out and compete and steal the business that you've brought to him, so that you'll see covenants in that case.
And in Michigan, that is really relevant because we're still the automotive capital of the world. We have a lot of manufacturer sales representatives that are technically independent, and they are not necessarily employees. And we run into the covenant issue, and as you know, because I know that you're working on some matters right now, that become real important because you've given to this individual the ability to be the point person with the customer, and often it's the largest customer of your business.
Yeah. So the real point is, it's not just employment agreements. It's whenever you have a relationship with somebody, you want to contractually protect yourself so that they don't come and compete against you. But we want to look at this from both perspectives, not just the one who gets the covenant. What about the one who's signing the covenant? What should they do, particularly in the employment context? Now, one thing is, why are people always questioning whether they're enforceable? What is it about covenants not to compete that even bring it into a question? Because basically contract law says this: a deal is a deal. That's the premise of commercial law. Our whole system is you can contract with one another on the terms you decide, and you'll be bound by your obligation.
You know, these employment agreements too, these covenants, are non-dischargeable in bankruptcy. People seem to think, oh, I'll just go do what I want to do, and I'll file bankruptcy and I'll get out from under the covenant not to compete.
Because it's not a monetary thing.
What you can do is, if you damaged your former employer by violating the covenant, you possibly can discharge the violation, but the covenant will still survive through the bankruptcy, and so you come out on the other side. You can't make the same mistake twice.
Yeah, it's a really important point. It's completely not answering the question that I asked, but it's a great
I
point.
can answer it. If you'd like me to actually answer the question.
In 40 seconds or less, tell me about the antitrust component.
Well, it's because at common law, and that's, let's just say historically, covenants were not enforceable. Historically, covenants, you couldn't restrain somebody from earning a living. You couldn't have these antitrust things.
Because our basic premise of law is against restraints on competition.
And now there's
Follow
been
me?
exceptions, especially since the mid-'80s and forward in Michigan and almost every other state in the union, that when they are done properly, and we're going to get into that after the break, reasonably and legitimately, then they become enforceable, and that's where things typically go awry.
We're going to take a break and look at when are they enforceable and what are your rights. We'll be back.
It's devastating, the effects of debt and foreclosure on you and your family. There is a solution.
Worth Ave Gross, our firm will solve your problem. Some fear the word bankruptcy, but in reality, it's a strategy to save your home and to eliminate debt. If you're in financial trouble, timing is critical. You need to take action now. We've been saving homes and eliminating debt for over 33 years.
Call Fav Gross 888-235-HELP. Carrying too much debt? Resolve your debt. Call Fav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Fav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Fav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross, our firm will solve your problem.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross, our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Fav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Fav Gross today, 888-235-HELP.
Welcome back. All right, so when we came up to the break, we were talking about the covenant. Now I want to focus on what's the standard as to enforceability. In one word, what would you guys say, anyone volunteer, the most important rule, key word is?
It has to be reasonable.
Well done, Brian. Following the outline just as I created it. I love it. But when we talk about reasonable, we're talking about two things. It has to protect a legitimate interest, and it has to be reasonable in terms of the scope and the time. When scope really comes out to time and distance.
And think about what we said at the top of the show. Just give them a standard form. That's where things go off kilter, because reasonableness in the covenant world must be tailored to the specific facts. So you could have a covenant that is completely reasonable, and the scope of the restriction, for example, could be southeastern Michigan, or it could be a city, or it could be a township. Or if the facts are right in the internet world, it could be North America, it could be the world. It depends as what's going on. That's why there's no standard form.
It depends. I'll come right to you, back to you. It depends. If it's an employment context, it depends on what is the range of the employer's business and what is that employee doing for the business from the standpoint of scope in terms of time, the length of the covenant, and how broad the geographic region is. In terms of legitimate, from the standpoint of a legitimate interest, the employer can't restrain the employee from doing everything he wants in the world. He has to only restrain him from doing the things that he really conveyed and put the employee in the position to learn through his employment. Is that a fair statement?
Absolutely, 100% correct. How many times have we sat at this desk and a client has come in and said, I've got the best covenant. He can't do anything. She can't do anything. They're locked up for 5 years. I'm totally fine.
Totally unreasonable.
And you say, well, that's not good.
Yeah. You can't prohibit the guy from barking if he wants to go and be a salesperson. You only can prevent him from selling the same widgets he was selling for. Brian, I know you're dying to say something.
No, but the problem is that that's not reality. The reality is most employees are going to sign that covenant when it's put in front of them, no matter what. They don't know that they can negotiate it. They don't know
Correct.
that
we're going to do a case study right on that,
that they're not restricted, even though the law says, even though they sign something that says you can't produce widgets for the rest of your life.
They need to know to fight about it.
That's right. So
when
most
do they have
people
to
aren't.
fight?
I'm sorry?
When do they have to fight?
Immediately.
It's not a question
After
of fight.
well,
the word starts with an N. Anybody have it?
Negotiate.
Negotiate. Before you enter into the contract, you have the ability to say, hey, this covenant is too restrictive. I'm not willing to do it. Now, you got to put it in context, though. If you've had 0 job offers and this is the only job on the table and you've been looking for 9 months and it's going to pay you good money, and the employer says take it or leave it, then you're in a difficult situation because you might have to take it because you need the cash. However, if it's today's market, where right now it's a pretty good market for employees and you got 4 job offers and they're all pretty good, then you go back to the employer and say, hey, this is no good. I got a better deal from someone else. I'm not going to sign your covenant. It's got to be narrower. It's got to be shorter, and maybe only a non-solicitation rather than a non-compete. And I need to identify what's the difference.
Huge difference.
A non-solicitation covenant is what?
In essence, it's that you're not going to, the person restrained, let's say it's an employee, is not going to actively seek and solicit the client's customers or contacts of their employer.
But other than that, he can go and compete.
Well, yeah, and he could even conduct business with those clients of the employer as long as he didn't solicit them. And there's plenty of case law out there that just notifying people where you are is not necessarily solicitation.
Now, sometimes when we're representing the employer, the one getting the covenant, we go one step further. We go with non-solicitation and non-acceptance, which means not only can you not solicit the business.
They're not acceptance.
You can't be quiet and have them come to you and say, we want to do business with you. But even that is better than a covenant not to compete, because the covenant not to compete takes you out of the marketplace in that region. The non-solicitation says, I can still work, I can, quote unquote, from Jerry, earn a living because I can go out and make new sales. I can't just tread on the business that was created by my employer while I was in his employ.
Well, Ken, people
it's a better
who think
deal.
they've signed an unreasonable covenant not to compete, though, I don't want to tell them, no, just never leave, never compete. I think they need to have that contract looked at and see what the risk of litigation and the risk that they would lose that suit would be.
Absolutely. You don't just assume you can't do it, but you need good advice on it. You don't want to. What you don't want to do is listen to Jerry and say, "Hey, don't worry about it. Covenants are not enforceable." The basic rule is covenants are enforceable if they are reasonable.
You do have to recognize, though, that if you are going to be fighting on the backside,
it's going to cost you money.
It's going to cost a lot of money. It's not cheap.
And it's risk.
But Ken, here's the perfect example, because you love to role play. You're the judge, and I
like to be the judge.
And I'm the defense attorney, and I say to you, Judge, this is completely unreasonable. This is a mid-level employee who doesn't have access to a lot of confidential information or trade secrets, and now he can't pay his mortgage because he can't work within 50 miles for 5 years. That's absolutely unreasonable. Or if it's a scenario, I'm the plaintiff representing the employer, and I say, Judge, Mr. Smith or Mrs. Smith can work next door, and they can conduct business with anyone they want in the world,
just not my
not
customers.
Those customers on our customer list.
And you know what I would
that's
do?
reasonable.
If I was the judge, I would say, Counselor, those are good points, and I want to refer you to a case study. The case study is what we're going to cover next, which is Sarah. She's an account executive for a pharmaceutical business. She's been in business for 20 years. She knows many doctors and hospital clients in the area, and XYZ is offering her a job. And in that job, the good of her job is she's going to make $120,000 a year. I'll give you the rest of the good of her job and the bad of the job offer when we come back from the break.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
Worth Ave Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
A lifetime of hard work. If you're approaching retirement and don't have the right plan in place, you can lose your home, your investments, and your savings. And you didn't come this far to lose everything. Putting a solid strategy in place with Samasco Law legally protects your assets as well as your wishes. Since a will doesn't cover you medically or financially, Samasco Law goes beyond ordinary asset management protection to safeguard everything you have.
How much can you afford to lose? Call Samasco Law today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP. If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross. Our firm will solve your problem.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Fav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Fav Gross today, 888-235-HELP.
It's announcement time. I would go to David and say, do the announcements, but I don't think so.
I'll do them. You want me to do them?
No, I do not. I'll do part of them. Okay. I want to remind our audience to listen to us Tuesdays noon to 1, 6 to 7 p.m. on WCHB 1200 AM 99.9 FM for Law and Reality Live, and on Thursdays 3 to 4 for Law and Reality Now on 9:10 a.m. with Cliff Russell. Seminar coming up Wednesday, July 13th, 2016, 6:30 to 8 p.m. Very important name, but it has to be said in the proper manner. I don't think that there's anyone at in the panel that's willing to say it the correct way other than myself.
Please.
So I will announce the name of the seminar.
Indulge us.
It is There's No Time Like Debt Elimination Time. Not singing, just a little bit of a chant. Covering all the issues that we talk about on the show on a regular basis. Should I file bankruptcy? Should I get rid of my debt outside of bankruptcy? Should I settle my credit card debt? What do I do if I'm facing foreclosure? The big focus is draw a line in the sand, preserve your future income for you and your family.
I have
so
a
that
better
you get
name.
rid of the debts in the
I
past.
have a name for it. It should have been. It should be. Should I stay or should I go now? You would have liked that.
We'll do that for the next one. Isn't there a copyright issue with that, though?
No.
Probably.
As Law and Reality. That's Wednesday, July 13th, 6:30 to 8 o'clock p.m. Sign up at thavgross.com or lawandreality.com. Seminar's free. You get a free copy of my book, Dump Your Debt. Seminars fill up fast, so I encourage you to get your application in early. It's not an application. You just have to register. Also, you can call 888-235-HELP, and you can sign up by phone. 3 free reports on the website: Business Formation, Loans and Grants in Detroit, Retiree's Guide to Social Security from Pat Samasco, and Reg X, How to Save Your Home, The Hidden Secrets by yours truly.
What about
Those
Dump
are
Your
free.
Debt?
Just go to the website.
What about Dump Your Debt?
Dump Your Debt is the book. You get that by coming to the seminar for free, or you can go online on Amazon and pay big bucks for it, and it's worth every penny. I promise you that. Back to Sarah's situation. The good was the offer's $120,000 a year. She gets a company car, great benefits. Her territory is the state of Michigan. She's a pharmaceutical rep. She's going to call on the doctors and the hospitals. Good job. This is her. This is what she does. The bad. The contract says she can be terminated anytime at will. She can also quit anytime she wants at will. And there's a covenant not to compete that she cannot engage in the business of a pharmaceutical rep for 3 years in the states of Michigan, Ohio, and Illinois. There's also a non-solicitation that says she cannot accept or do any business with any existing client of the company at the time of her termination for 3 years. Question number 1 goes back to what we were talking about before the break. What should Sarah do at the negotiation stage? First word, negotiate. Bargain is what you need to do. What were you going to say?
Well,
what do you want to try and
I
do
just
on
need
that?
to, I need to clarify. Does Sarah have any existing experience?
Yes, she does.
Okay, and so that's
She's
the
called
first.
on doctors and hospitals in the area
For 20 years.
for 20 years.
Okay, that's what I wanted to emphasize. So right then and there, she has her own contacts, her own goodwill, and her own relationships that she's bringing in. And if the employer doesn't do anything to increase that goodwill,
Then there's
then
arguably
you
no
get into
legitimate
that.
interest.
Then you get into that you didn't do anything that was legitimate that you need to protect. Sarah brought all of this in. So what you do in the negotiation stage is you first of all you try to carve out right off the bat the book of business that I'm bringing in and the relationships I'm bringing in, I get to keep.
So, like, you make a list of all of our clients and all of our hospital contacts and say, I can continue to call on these after I'm terminated for any reason. That would be one way of accomplishing
Well,
it.
that's
You
the
also,
first part.
On the covenant not to compete, you want to reduce the scope in terms of, right now it's a 3-state restriction when she's really only going to be working in the Tri-County area. That's unreasonable, so she should try and narrow that and reduce the number of years from 3 to 1. She starts off saying, I'll give you 1 year. They say 3. The point is this, if she's a good rep and they want her, they're going to, people don't think that the employer will bargain, and they don't always bargain, but sometimes they will. If you don't ask, you do not receive.
There's another aspect to this which is critical if you can get it from the employer is, if you can convince the employer that, hey, if Sarah decides voluntarily it's just not working out for her, and she voluntarily quits, and there's no bad act, there's no stealing, anything like that, then Sarah should say, I agree to abide by the covenant as negotiated. If I quit.
But if you fire me for no reason.
If the employer says, hey, the margins aren't there, the market's changed, I can't support it anymore, I like you, I love you, but I got to let you go economically, then you should be able to not be subject to the covenant. If you don't ask, you don't get.
And if, saying it another way, if the employer just says you're released, you're gone for whatever reason, shortly after you've become an employee, you're bound by the covenant unless you had a provision that says the covenant only applies if I voluntarily quit or I'm terminated for cause. That's a good thing to bargain for, and oftentimes you can gain that through the negotiation process because it's a fair type of a provision. It depends on how reasonable the employer is. What if Sarah's terminated? She wants to go work for ABC Pharmaceutical located in Lansing. What are her arguments? I can say she only worked in the Tri-County market. She has no clients in Lansing, and suppose she says XYZ has no clients in Lansing. Argue that the covenant was overbroad because it did not need to cover 3 states. And then you get into this 3 states. What's blue pencil stuff?
What the statute says in Michigan is that any covenant that is brought before a judge, or it could be an arbitrator with jurisdiction, that if the judge or arbitrator believes that the covenant is unreasonable, that judge has 2 choices. They can modify it, take a blue pencil and modify it, or the judge can rip it up and say no covenant. Either one.
Here's the point. Covenants not to compete are enforceable if reasonable. If you're looking at it in the context of employment, you need to know to negotiate. If you haven't negotiated, now you're moving on to new employment and the employer is claiming he's going to sue you if you violate the covenant, you need counsel to address the issue, to examine, do you have legitimate arguments to prevail on, because you may be looking at a big fight ahead of you. The important message for everybody is don't listen to Jerry the bartender. Covenants not to compete are a major issue. More often than not, they are enforced against the employee. You need to be very careful on that issue. Next week, we're going to talk about something a little bit different. It's going to be, what do you do if your business is struggling? Have a great week. We'll be back with Law and Reality next week.